Today on Don't Talk TV, I thought I'd take a quick look at three stories that have caught my attention from a legal perspective. The first being the recent arrest and detention of Tamara Lich. The second being C11, the bill to make channels like this subject to the CRTC. And thirdly, the recent announcement that James Topp, who I interviewed a few weeks ago, is going to be court-martialed. Hello, my name is Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So there's a number of things going on this summer. The media is telling us that we're in the midst of a seventh wave and we should be locking down again and wearing masks again. I know CBC Radio in Kitchener was talking about the fact that wastewater levels are showing heightened levels of COVID-19. I personally haven't noticed too many people being sick or heard of anyone taking time off work due to sickness. But aside from what the media is wanting to talk about a lot, there's other interesting stories. And I mean, the first one is one that the media has covered, and it's one that a number of people have asked me about. It's that being the situation with Tamara Lich. Now, I've been very hesitant to talk about this because most of what I can do is only speculation because of a publication ban on her bail hearing. So we don't have any of the evidence to know what exactly went on there. Now, a lot of people are upset of why aren't we hearing anything about it? Why is there a publication ban? Well, publication bans under Section 517 of the Criminal Code are actually there to protect the defendant. It prevents the publication of evidence led at the bail hearing so that that doesn't taint future trial proceedings. At a bail hearing, generally the Crown Attorney just gets to read a summary of facts made by the police into the record without cross-examination by the defense, so it's always a somewhat skewed, certainly the best possible case scenario for the Crown in terms of evidence, and that's not the way things will play out at trial. So it's completely normal, and again, it's to the benefit of the accused person to have a publication ban. What we do know, however, is that Ms. Lich's bail was revoked. Just looking at an article from last week, July the 8th, and it just says here that Freedom Convoy leader Tamara Lich's bail has been revoked for violating the conditions of her release when she attended an awards gala in Toronto and had contact with another convoy organizer. Now, the attending at the awards ceremony, I don't see how that's a breach. Viewers may recall that, in fact, that was brought up in court already. The Crown wanted to revoke her bail when she was to be given that award, and a Superior Court justice said that, no, that's not a breach to receive an award. So it seems like a bit of a stretch. Now, contacting someone she's not supposed to contact, that could be a legitimate breach of bail. We'll have to see. But the whole thing is very unprecedented, and as someone who does bail hearings on a weekly basis, I routinely get people out on bail who have multi-page criminal records, who have multiple charges. I think I have an individual who's been granted bail recently with 12 or 13 different sets of charges pending against them. And as you can imagine, after the first one, this next 12 involved breaches of bail. So for someone like Ms. Lich with no criminal record to be denied bail is very, very unusual, and it really smacks of political persecution, something we historically haven't seen in Canada. Just very quickly, Section 515 sub 10 of the Criminal Code of Canada lays out the requirements for a justification for detention in custody. So there's basically three. The first is where detention is necessary to ensure attendance at court. It's called the primary ground. Secondary ground, or sub B, is where detention is necessary for the protection or safety of the public. Now, it's not just that it's preferable, it has to be necessary for the protection or safety of the public. And then the tertiary ground, or third, is if the detention is necessary to maintain confidence in the administration of justice, having regard to all the circumstances, including apparent strength of the prosecution's case, the gravity of the offense, circumstances surrounding the commission of the offense, including whether a firearm is used, and the fact that the accused is liable on conviction for a potentially lengthy term of imprisonment. It's difficult for me to see how any of those three grounds would apply to Ms. Lich, certainly to the extent that it's necessary to detain her in order to protect the public or prevent the continuation of any offenses. But she has very capable counsel. I believe it's Lawrence Greenspan who's now representing her, so I'm sure he'll do an excellent job for her, and we'll have to see what happens in the future. Now, the second thing I want to talk about is Bill C-11. I don't have time to go into a deep dive in this. I tried reading it, and frankly, I think my IQ dropped by about 15 points in the attempt. It's very difficult, very dense, very convoluted the way it's worded, with lots of different changes here and there. But you can find it on parl.ca under the Legis info. And C11, just to remind you, that's an act to amend the Broadcasting Act and to make related and consequential amendments to other acts. So the very short version of this is they want to make things on the internet, they want to make YouTube, they want to make channels like this one and others subject to the CRTC. We've seen how that went with television. I don't see anything good coming of. The internet has been a haven of free speech since its inception, and it seems that the Liberal Party of Canada and their accomplices, the New Democratic Party, want to bring that to an end. Now, just to look here, the status that it's at, it's made its way through the House of Commons. Third reading was completed on June the 21st. It's now with the Senate, so a Senate pre-study was completed on June 21st, as was first reading, and now it's currently being considered in committee. If you don't want to have the Government of Canada controlling what you're allowed to view and read about and study on the internet, I invite you to contact your senators and encourage them to stand against this. The senators appear to have been the ones who caused Justin Trudeau to revoke the Emergencies Act because it looked like they weren't going to ratify it. So I think there is some hope there. They are willing to defy him, even though most of them are appointed by the Liberal Party of Canada, and specifically Mr. Trudeau. Which brings me thirdly to the case of James Topp. You may remember a few weeks ago I interviewed him live while he was marching with, I think, 40, 50, 60 pounds on his back on his march across Canada. He's made it to Ottawa. And what's happening now is he's going to face court-martial over criticizing the vaccines in person. You can find his video online. I'll put a link in the show description for what he said, but he did say that the vaccine mandates are wrong while in uniform. So members of the Canadian Armed Forces are supposed to be apolitical, and therefore it can be an offense to criticize publicly in uniform political decisions or decisions of one's chain of command, because that can break down the morale, the discipline in a military unit. So in normal times that certainly makes sense, but just to look here again at the article, it says here that Warrant Officer James Topp was recently notified that he will be allowed to have his case heard in a military court instead of by his chain of command, according to the Army Reservist civilian lawyer. So a lot of people were upset when they first heard this, but I think this may actually be a good thing. It's certainly something that I think Philip Millar, James's lawyer, it's something that he was pushing for, because although the court-martial has potential for greater penalty, it has way more due process. He's allowed to have a lawyer, he gets to have a full trial, and a full court process to have this adjudicated properly. So I think that's a good thing. A summary trial, that's just before your commanding officer. You're basically brought into a room, you have an assisting officer. I mean, I was an assisting officer once way back in the day, I think 2000, probably around 2000, when I was a second lieutenant in the infantry regiment I was in. One young troop got charged with something. They're like, hey, you're going into law school, you can be as assisting officer. Even, I mean, I didn't know anything about the law or military law at that point. But, you know, it's just something that happens in-house within the unit. There isn't much due process. Now, there aren't a whole lot of penalties that could get handed out. So, you know, on balance, I think if he wants to have his day in court and have more visibility to what's going on, this is something that Warrant Officer Topp wanted. So I don't think it's necessarily a bad thing. So if this video isn't legal advice, of course, if you need legal advice, call a lawyer. You can call another lawyer or myself. My phone number and website are listed below. If there's show topics you'd like to see me cover, please send an email to the email address listed below or leave a comment in the comment section. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media.